Good afternoon. I'm Steve ElVille with ElVille and Associates, and this is Jeff Stauffer, our Community Relations Director.
Hello.
And this is the first time we've been to Gaithersburg Senior Center, and I thank Steve for probably becoming part of me coming here today. And we are very happy to be here. I actually just spoken to a gentleman who I hold in high regard that has an office near here, in Gaithersburg and Germantown area. So I just told him I'm speaking here, and we're thinking about forming a relationship. So this is really an area that I think is underserved. So the whole Gaithersburg, Germantown, North area. So we're very pleased to be here. How many of you have ever had one of these days where things don't exactly go right? Never. I woke up this morning and got my breakfast and everything, got ready to walk out the door and saw that I put a big flop of something right here on my tie. So I washed it off, I went to the next appointment, looked at myself in the mirror, and there it was again. So it's just one of those days. So even lawyers experience these things. All right. What we are here today to do is talk about fundamentals of estate planning and elder law. So everywhere I go, whether it's in Montgomery County, wherever it may be, Silver Spring, Howard County, Baltimore County, people have questions. And you may have questions today. You may have some unanswered things in your mind, something that's bothering you. It could be about healthcare decision making. It could be incapacity planning. It could be about what is this particular thing that has to do with estate planning. So I just want to take a few minutes, which I always do, to take some questions if you have any. So I don't want you to feel pressured, but if you have some questions of any kind, this is the time you can ask them. And hopefully I'll have the answer for you. Yes, sir.
Our new governor, has he, his policy is going to reflect on the elder plan?
That's a good one.
All right, that's a good question. And because I'm sometimes so busy, I don't follow everything like I should. What is it that you're concerned about that he said that might have led you to say that?
Reductions in some social programs that were talked about that could help the senior citizens.
Okay. I would say that, God willing, the basic infrastructure that's in place for special needs people, the social services network structure. Maryland is one of the more liberal states in that regard, as is Wisconsin and Massachusetts and New York and those types of states. So I haven't heard anything in that regard, and I certainly hope that wouldn't be true. Now, in some areas of the state, Montgomery County, Howard County, and some of the more, I would say, upscale counties is the best way to say it, the social services network seems to be stronger than in other areas. For example, I have some clients in Howard County that have some special needs children, and the one thing they're concerned about is keeping that special needs child in that particular area because the support is so strong. And I'm sure there are other examples of strong support. So anything that would shake the core of that support system, of course, would be devastating to a lot of people. So I would say I haven't heard anything in that regard, but we are living in an era where even though Medicaid services, which are federal and state, those are always in flux. Every state has their own Medicaid laws. So Maryland's continue to be quite liberal. And surprisingly, a couple of years ago, there was something called Manual Release 159. And Manual Release 159 actually relaxed the provisions about gifting and other things that are still penalized under the laws, but it relaxed the rules because it used to be that if you made a gift and then you applied for Medicaid, you were automatically presumed to have made that gift with the intention of avoiding the Medicaid laws, or getting around the Medicaid laws. Now, Manual Release 159, which is very surprising, gives several criteria for ways that people may have given gifts, but they won't be penalized. There will be no presumption. There's not supposed to be an automatic presumption that that was done for that purpose.
What's that reference again?
Manual Release 159. And if you want to torture yourself a little bit, you can look up Manual Release 159. You have to look for it carefully. But if you look at, I'm just going to say this off the top of my head, the Department of Health and Mental Hygiene and manual releases, because there is something called the Medicaid Manual.
All the way there?
And the Medicaid Manual, when I was a young associate, the Medicaid Manual was something you could barely read because it had to be printed and sent to you from the department. Now it's right on the internet. And you'll see these manual releases and you can read MR 159. And MR 159 is actually pretty readable.
Okay.
So I say I've heard nothing, but God willing, nothing will change in that regard. You're welcome. Other questions that you may have?
Yes, I just got one question, sort of on the technical side, but I'm unclear how to deal with IRAs and 401ks and revocable trusts.
Okay, very
I'm
good.
also not sure if such a trust in Maryland would apply in some other state.
Okay. When you say a revocable trust, would it be valid in another state?
Yes.
Okay. Boy, this is a sophisticated crowd, I tell you. This is good. That's a wonderful question. Okay, so how do I deal with retirement plans, basically, and revocable trusts? Okay, so here's the short answer to the last part of that question. The revocable trust is valid in any state. So let's say that I have a trust here, and I move to Chicago. Okay. What I would do is I would, first of all, check the local law there. And I just use Chicago as an example. But I believe that Illinois is a common law state and not a community property state. So for example, I would simply change the location, probably, of my trust to Illinois versus Maryland. But my revocable trust is still good. Now let's say that I don't change the location, which means the situs of the trust. I keep the state law as Maryland and I keep the situs as Maryland because I still own a house in Maryland, let's say. That's fine. I still have a Maryland trust governed under Maryland law. If there was ever a dispute about my trust, it would be adjudicated according to Maryland law. But let's say I move to Illinois, buy a new house, probably it makes sense to change the situs, meaning the location, and the state law of the trust to the new state. Now, good trusts today, meaning trusts that are, I guess, have all the modern techniques that we should use in planning, are going to have tax provisions that are applicable to any state. And they should have, if you're married, it should have estate tax formulas, for example, if that's used, that accommodate whether there is any state estate tax or not in that particular state. Now, most states have abolished state estate tax, and Maryland is in the process of phasing out its state estate tax, or at least phasing it up into the federal scheme. So my point is that trusts should be designed so that they can adjust to whatever state you're living in. Worst case scenario, you would restate the trust completely. But if you've got a trust and you've already funded it, all you'd be doing is restating the terms of the trust without having to refund it. Now let's talk about retirement plans and revocable trusts. All right, so this brings up a good subject that is a good thing for you to know about. I'll first start out by saying your retirement plans are creditor protected. They have creditor protection. They have asset protection. And you probably know that. So you have asset protection. But when we die and we leave our retirement plans, and this does have to do with revocable trust, which I will eventually get to. When we die and leave our retirement plans to anyone, our children, nieces and nephews, whatever it may be, due to a new Supreme Court ruling this summer called the Clark case, we may not have creditor protection anymore in our inherited IRAs that we leave our children.
What act is called?
Inherited IRAs. I'm sorry?
No, you said some act.
Oh, the Clark case.
The Clark.
Clark
Is that
case.
the one decided by the Supreme Court?
Yes. Yes. So the Clark case was really simple, in essence. And let's start with what happens at retirement, or excuse me, when people receive our retirement assets. Well, You and I are subject to the lifetime minimum required distribution rules. But when we die and leave it to our children, nieces, nephews, whoever it may be, they then take it at their life expectancy. So let's say I die, leave something to a 45-year-old. My IRA goes to a 45-year-old. That 45-year-old takes an inherited IRA, and they can do one of two or three things. One, they can take it for their life expectancy, which is what we want them to do. They can take minimum required distribution every year. They must take it every year for the rest of their life. And if they leave the balance of the assets alone, those assets continue to grow, tax deferred. Now, the second thing they can do, which we don't want them to do, is they can cash it out in 5 years. That's called the 5-year rule. They have to take it no more than 5 years. The 5-year rule. Or they can just cash it out altogether and pay the tax all at once. Now, the reason I say all that is to say this. In the Clark case, a daughter received for about $400,000 in an IRA, and it was from her mother, so it was an inherited IRA. And my recollection of the case is that she took minimum required distributions for about 8 years, and then she and her husband filed bankruptcy. And I think when they filed bankruptcy, there was about $300,000 left in the IRA. And they expected that this would be excluded from the bankruptcy estate. But what happened was it was included, and they lost their $300,000. So they appealed to the Supreme Court all the way up, and the Supreme Court said, we agree that this is not a retirement asset. So to make a long story short, when it comes to an inherited IRA now, the Supreme Court says it doesn't have the same attributes as you and I have when we're accumulating retirement funds. It's just like an inheritance. So as far as this federal level goes, inherited IRAs are not creditor protected. Now, on the state level, there's still some conjecture, even though in my mind there's no question. State law says that IRAs are protected, period. But would you and I want to test that? I wouldn't want to test that, now that the Supreme Court has ruled that they're not protected. So I'm not saying we will receive no asset protection on the local level, the state level, but I spoke to a very renowned bankruptcy attorney in Baltimore on another matter about 3 months ago and asked her about this, and she said there was no question in her mind people should not rely on inherited IRAs being protected. So with that said, your question, sir, is how to deal with that. So, if you have a revocable trust, I'll give you the simplest answer I can give you. You can use the trust as a funnel to funnel in the IRA assets straight down into the trust to your beneficiaries. And I'm going to try to keep this simple because it's not simple. If the trust says the right things, it is what is called a designated beneficiary, the trust. And if the trust is a designated beneficiary, if it meets the requirements, the IRA goes through the trust and then it just gets distributed out to the beneficiaries just as if you had not used the trust. Okay? The problem is that there's no separate treatment for the different ages of the beneficiaries. There's no separate accounts rule. So let's say that I have a trust and one beneficiary is 45 and the other one is 28. If I just leave it through the trust, the 45-year-old's age will control for all distributions. So the 28-year-old will still get his or her share, but their distributions will have to come out based on the age of the 45-year-old. So they would not be able to stretch things out as long as the 45-year-old. Now, let's go back to the Clark case and asset protection. If I leave an IRA through my revocable trust, just using my revocable trust as a funnel, do I get any creditor protection? And the answer is no. What I have to do is I have to leave a trust for my beneficiaries under my trust. So I'd have to have subtrust. There you go. Boy, this audience is sharp. Wow. Okay. And I have to have this subtrust, okay? And now I have a shell of protection here, okay? So this is my subtrust number 1, okay? And here's the IRA. If I leave my IRA beneficiary as the subtrust, not the trust itself, and if I make this trust what is called a designated beneficiary, and it can be one of two things. It can be called a conduit trust. The conduit trust is the simplest kind. It says my 28-year-old is going to get minimum required distributions for sure. That's going to come out of the trust. But everything else is going to be accumulated in the trust for protection. Now, what if I have a beneficiary that has some spendthrift problems, their substance abuse problems? I'm not going to use a conduit trust. I'm going to use something I would call an accumulation trust. I'm going to accumulate everything in the IRA trust.
Can I ask you a question?
Yes, ma'am.
What happens if this trust is designated to, say, Princeton University?
Okay.
Other university, how would they do that to pay RMD?
Well, if you were going to do that, I would not use this subtrust.
Okay.
And it's complicated, but I might just leave it directly to them. You would not need to do this for asset protection.
Because we don't
Right.
need it.
Yeah, so they are going to be a public charity, perhaps, okay, and you would leave that directly. Now, you can leave it through trusts, but it's much cleaner just to leave it directly.
Okay. And they don't have to do the RMD stuff.
No, and they don't pay taxes.
They don't
See,
pay taxes.
see, depending on whether they're a charity, they don't pay income tax.
A non-profit, like, private university or university of income, whatever.
Right, they're not subject to, even if they do want to take it piecemeal, they don't pay tax.
Oh, that's right.
Yeah.
Okay.
So actually along those lines, if you make these charitable type gifts with your retirement assets, you're actually giving more.
Yeah, because no tax. So thank you.
At the time we did our revocable trust, we understood that the IRAs would be left out of the trust.
Right.
Now, is that still true? And then the
Yes.
children could decide whether to take a lump sum or do the RMD?
Right. So this is a very good point. And thank you for indulging me in that conversation. So your answer to your question, sir, is you leave it straight through, or you leave it to a subtrust if
And
you
I
want
also might
protection.
add this question too.
Yeah. So let's go down to this question and say, okay, here's my IRA, here's my revocable trust. Let's get rid of this for just a second. We know that in a revocable trust, you have two steps. One, creating the trust and designing the trust and doing all those things. Number two, funding the trust. So when we fund the trust, we never put IRA assets in the trust. We never do that. So you did the right thing there, leaving your IRA out here. Because the IRA is a special type of animal, and it can't be mixed with these things. If we did this, we would receive a 1099 in the mail, saying all taxes due. So we would never do that. So what you would decide, my marker's not working, what you would decide is, do I want to leave it directly to my beneficiary, okay? Or do I want to leave it to a sub-trust? Depending on the size of the IRA, it should not be left to a sub-trust. It should be left, and I'm talking about where individuals are the beneficiaries. Okay? It should be left to what I would call a standalone IRA trust, a standalone retirement trust. Because when you mix IRA assets in a sub-trust, and you all are very good, this is complicated stuff. When you mix IRA assets in a sub-trust with other non-IRA assets, you're creating a little bit of a mess.
Yeah.
Okay? So it's better, especially for large IRAs, to use a trust that will only handle IRAs. Now this is if you're trying to provide asset protection in a trust. There's nothing wrong with leaving it to someone outright. and letting them decide what they're going to do with it. But if you use a trust, you can leave it to that beneficiary. You can give them a shell of protection, right? This is our shell of protection. And they can enjoy some creditor protection if they ever file bankruptcy. So, nothing wrong with doing this. It's just that now probably there is no creditor protection for the beneficiaries. Now, let's say you're a surviving spouse. Between spouses, you can roll it over to your own, or you can take an inherited IRA. Which one would you take if you were a surviving spouse? Well, if you took the inherited, the law is still in flux, because even surviving spouses, inherited IRAs may not be creditor protected. I'm not saying the surviving spouse is going to file bankruptcy, but what if they did? So I would always take the rollover, and I would not deal with an inherited IRA right now. Yes, ma'am?
Are you familiar with the government TSP program?
Yes.
Okay, I'm a surviving spouse.
Right?
Now, I sort of left it where it was, but
All
are you
right.
saying now that I may be, and I think I read someplace that they would only let you take a lump sum, you could not, I mean, I'm doing my R&D, but as
Right.
an inheritance, they would
Right.
only let the inheritors take the lump sum and not continue, you know?
Well, I'd have to look at your particular case and when this happened. But, you know, TSP is a 401k. So I don't know at your husband's death whether you took basically an inherited IRA or what you took. I'd have to look at it.
That's a good question, because
Yeah.
they just changed it to my name, and I don't know what they did actually.
All right.
So I'm-
Yeah. If it says, if it's an inherited IRA, it will actually, it's kind of weird. It will actually say your husband's name, and then it will say for the benefit of you. So how it's titled is really important, and who did what, and when did your husband die, if you don't mind?
11.
Okay, okay. I would have your financial advisor look at it, and if you don't have one, there's plenty of good ones. Look at it and really determine, especially if it just happened recently that you see some change, I would take a look at it as to what happened. What a lot of surviving spouses experience, may not be your case, is, you know, now I need to manage these things, and let's say 401k at TSP was always good. It always was very good, and a lot of people are in love with that, right? But now, when someone dies, sometimes it's good to get the perspective of a private advisor. And there's plenty of certified financial planners that you can have confidence in. Anyway, I got off on a tangent there, but that was a very good
One
question.
question, the TSP, you can, directly you can assign a beneficiary in TSP plan. Does that have to be within the trust? Or
No.
will or anything?
No, your TSP is just like a 401k. So at death, it becomes, now, let's just say at death, it typically becomes an inherited IRA. It's an IRA. All 401ks pretty much become IRAs at death. So we're talking about the same thing, inherited IRA, you know, most of the time. So at the end, the threshold question with retirement plans is, do I want to protect the shares of the beneficiary? And nowadays, if you do, you have to be proactive with that.
So how do you do that?
You either use a sub-trust under your trust, or you would use a standalone trust. It's I recommend that you use a standalone trust, especially for larger amounts. And I would say a larger amount is anything over $200,000.
How does that compare or influence if you have a will?
All right, good question. You can have a trust under a will. So anything that you can do under a revocable trust, you can pretty much do the same thing with a will. The question is whether or not you want probate or not. So remember that you can have a will, or you can have a revocable living trust as part of basic plan. It's just it's a preference between probate. So what is probate? Probate is the court process of proving a will to be valid. Proving a will to be valid. And that process in Maryland takes around 9 months. Average. So sometimes it's more, sometimes, and it's not very often less. Now, the cost of probate is 4 to 7% on average. And now let's clarify that. When I say the cost of probate, I'm not talking about how much the Montgomery County Register of Wills charges. I'm talking about the total cost. Lawyers if they get involved, CPAs if they get involved. This includes California and New York, some of the more expensive places. In Maryland, in my opinion, it's around 4%. Now let's say that your personal representative takes care of everything for you. This is a spouse, this is a child, and let's say they don't charge a fee. Then the probate process is going to be much less expensive than 4%. But this assumes that there are professional people involved. Okay. Yes, ma'am?
I sort of understood that the trust would avoid probate.
Yes, so the trust is a probate avoidance device. That's the best way to put it. So some people think the revocable trust is more than that. The revocable trust, and it can be a little bit more than that, but typically it is a probate avoidance device. So whereas we have here this 9-month process that includes a claims of creditors period. Creditors can make claims here up to 6 months from the date of death. There is an accounting period here. And is this a good thing? It is a good thing, because some families need this. Some families need this process so that everything can be distributed. So I think it's a good process. But some people, given the choice, would want to avoid probate. Now, the cost of avoiding probate, let's say with a revocable trust, on average is about 1 to 2%, the total cost, on average, across the country.
That's court fees and...
Yeah. Now, you're not going to have, God willing, you're not going to have any court fees here, because this is a private document. So here we have a public document, and here this is private. Okay? The Register of Wills is really not entitled to see this revocable trust unless they have some interest in seeing it. Now, how can the Register of Wills have an interest in seeing a revocable trust? Well, let's say that I have a revocable trust and I leave everything to my daughter except $50,000. I gave $50,000 to my niece. Well, my daughter is not subject to inheritance tax, but my niece is. So the best way to think about inheritance tax, which is 10%, anybody who is a niece or nephew or beyond is subject to inheritance tax. So now, because I was a nice person and left my niece $50,000, the Register of Wills will say, oh, we're entitled to 10% on that $50,000. So now they want to see a copy of the trust. So that's the only way that I can think of that your revocable trust does not stay private, is when someone is subject to inheritance tax. But this is a probate avoidance device if it's funded properly. So you have to look at, you have to design the trust, and then you have to fund the trust.
And what do you mean by fund the trust?
Okay, so what I left out in my explanation, when we were talking about that IRA, here's the trust. So let's say I'm a typical person that has a revocable trust. I'm going to put my house in the trust. I'm going to put my non-retirement assets into the trust, like my stocks and bonds, my U.S. savings bonds, my CD, all of my savings account, those are going to go into the trust. Okay? My IRA will stay outside the trust. My life insurance will stay outside the trust. Jeff, my markers aren't working. My IRA stays outside. My life insurance stays outside the trust, typically. And although a revocable trust can own your life insurance, it typically doesn't. Your revocable trust would be the beneficiary of the life insurance. So with life insurance, you can use the trust as a funnel, just to direct the money right through there. So that's what I mean about funding the trust. So now if you have a fully funded trust, it avoids probate. Yes, sir.
When you referred to the 50,000 that's subject to inheritance tax, 2%, that's specific to a state that has inheritance tax, I think, isn't it?
Right. So Maryland, right. So that's a good question. So Maryland has inheritance tax, but thank goodness has abolished it as to most people. Except, yes. So husbands, wives, children, lineal descendants, even some daughter-in-laws, depending on whether they've remarried or not, are not subject to inheritance tax. Now in Pennsylvania, although I'm not an expert on Pennsylvania law, inheritance tax attaches to almost everyone at somewhere down the line. Okay, so probate avoidance is what a revocable trust is. Now, yes, so if you've got a revocable trust, you will avoid probate, as long as it's funded properly. So, what do most people do? And let's just take a second to talk about this. Why do most people that want to avoid probate, why do a lot of them still not avoid probate? Well, this may give you some clue about that. I belong to an organization that gave me this statistic a few years ago. So I'll let you guess. And B, you're not allowed to answer.
Okay.
First of all, you know most people don't do good estate planning. Most people don't. But the people who do, how many years go by before they come back and revisit their plan?
32.
32.
No, I said very few.
Oh, very few. I'm sorry. I'm sorry. Five.
Five.
Okay. The average is, I'm sorry, 19 years.
Really?
19 years is the average. So if I put a plan, if I put a plan into place and I don't come back and revisit it for 19 years at a time, just to give you an idea, between 2000 and 2009, there were at least 6 or 8 estate tax changes in the law. Okay, so what most people do, is this helpful?
Yes.
Okay. What most people do is they put a plan into place. That's stage 1. And then there is no stage 2, and then we die. Okay? And what happens here is that there's chaos. So when we talk in terms of a revocable trust costing 1 to 2% to administer, what I'm really saying is this. Stage 1 should be the planning and the design. Okay? So you get all that in place. And the funding. Okay? Now, let's stop right there. Most lawyers, according to the American Bar Association's ethics rules, will say we have no obligation to help our clients fund the trust. So let's get a trust in place, but we're not going to help you fund the trust. Now, that's what lawyers say. So does that make sense?
No.
No, that makes no sense at all. So a good law firm is going to help you fund your trust. Okay. Now you have something that can work. Okay. 2, this terrible word, maintenance and updating. Maintenance and updating. Most people never do this, but it's not their fault. Because year after year after year, decade after decade, lawyers deal with people in transactional fashion. Thank you for coming into our office. Here is your documents. Thank you very much. And that's it. It's a transaction. I didn't say that.
I did.
Now, I'm just saying, maintenance and updating is important. So, what happens in maintenance and updating? Well, let's say that all good faith efforts were made here to get everything in place, funding, everything that we thought was, everything was done. But 2 years later, we find out that there's another asset. And it's really nobody's fault, it just happened. Now, every couple of years, you have these couple of hour meetings, maybe an hour and a half, to make sure that everything's done. What if something has changed in a couple of years? We make a slight adjustment. But over the years, if you stay in touch with your attorney, you're going to have a plan that's fully funded and updated. What also happens during this time is that people continue to get educated. So, just like we talked about today. Gee, last summer, the Supreme Court said IRAs are not protected for beneficiaries. That's a big thing, right? So, learning these continuing things. I can remember lots of things that have happened. The portability laws, which we can talk about. The 3.8% Medicare surtax. All these things keep happening. Now, when we die, we have a plan that is actually going to work. And when we have a plan that's updated, and I'm going to call this final administration, now we have something that's not going to be chaos. One of my favorite clients, and it wasn't because of any other reason other than she's a lovely and successful person, lived at a very well-known Montgomery County facility. And when she came to Maryland from New York City, she had bank accounts in 20 or 30 different banks in New York City. Now, she was just a lovely person who loved to save money. Now, when she died, her nephew was still scrambling around New York City trying to put all these bank accounts in one place. And he didn't quite get it done, even though he tried very hard. So her estate turned out to be a lot to do because there was a lot of stuff in different places. But if you do this, you will have lower cost overall. And the plan will actually work. Yeah, there seems to be a lot of oh, and ma'am, I didn't answer your question about wills. So, revocable trusts are tools. They're tools. But a will can still be used, and you don't have to have a revocable trust. But most people with significant assets, whatever that may be relative to you, will choose a revocable trust a lot. Although the revocable trust is not necessarily the answer for everyone. All right. What does a basic estate plan look like? And you all know this, I'm just going to revisit this with you. This is kind of like practicing your favorite sport. You know, you just go back to the basics all the time. So a will handles what happens at death, obviously. It's a testamentary instrument. The powers of attorney, okay, these are incapacity planning documents. This is a very big deal, okay? So, 2 or 3 years ago, actually 3 or 4 years ago, Maryland came out with the Maryland Statutory Power of Attorney. This is very important because I remember when I was a young associate, people would come in with old powers of attorney and they would say, what's wrong with this? The bank won't accept it. That can no longer happen with the Maryland Statutory Power of Attorney. It must be accepted by law, except Merrill Lynch doesn't like to accept it. Everyone accepts it except Merrill Lynch. No, but it has to be accepted by law, and you can enforce it if someone won't accept it. And you can recover attorney's fees if they don't accept it. So it's got some punch to it. That's very important. There are 2 types. One is the short form, which is only 5 pages. That's the one we use. And then there's another one that's called the long form. And the long form, I don't remember how many pages it is, but it's 8.5 by 14, and it's about 20 pages. And the reason most estate planners don't use that one, even though there's nothing wrong with that, the reason most estate planners don't use it is because they would rather customize their own form. So what we do in my practice, and a lot of other people do this, is you have the Maryland statutory form and then a supplemental form that the attorney would customize for your use. And that way you're not kind of stuck with this generic looking form from the state. But there's nothing wrong with that form. That form is a very strong power of attorney. But a lot of people would like to design their own power of attorney and say, this is what I want in it, and this is what I don't want in it, and so forth. So this avoids guardianship of the property. So we can have the greatest estate plan in the world, but depending on how things are titled, if we have things in our own name, and if we become incapacitated, we are going to need a healthy power of attorney to take care of us. Okay? If we don't have a power of attorney, no matter how good we think we have been, we may be subject to guardianship of the property. The judge down here at the Montgomery County Circuit Court becomes our guardian. And when that happens, we lose our legal rights. So all of those fun things can happen. So guardianship is something we want to avoid. The average guardianship costs anywhere from $5,000 to $12,000, and a contested guardianship can be anywhere from $12,000 to $30,000, and there's some that are a lot more than that. Advanced Medical Directive avoids guardianship of our person. I mean, it'd be bad enough to lose our legal rights with regard to our money, but then we lose our legal rights with regard to our person. And all that is unnecessary if we have these. So if you have these and you keep them updated, there is I'm going to throw it out there, 95% chance that you're going to avoid guardianship. So Steve, if there's a 95% chance, what's the 5%? The 5% is this example, and I'll use my own case as an example. I have 2 stepsons, and I have 1 biological child, and they all get along. Now, what if someday they don't get along? Now, I'm in trouble. Because I might have said, okay, my stepson, the CPA, is my power of attorney, and my other son, and my youngest child, who's my biological child, is my, my third choice here. And they may not like that. My biological child could say, wait a minute, I don't like what you're doing with Dad's money, and I'm his biological child. So now I've got this dispute in the family. So we don't want that. Because when that happens, these documents can break down. The judge down here at the circuit court will say, well, Steve's got these documents, these look really good, but they're not working because his kids are fighting. So that's what we want to avoid. That's the only way that I can see a breakdown where you would have a guardianship. Either run out of agents, which we never want to do, or have a breakdown of the agents. Now let's say that this is a revocable trust. Revocable living trust is not magic, it's just a private contract, right? And it controls a certain amount of our assets, even though our retirement accounts are up here. Okay? Now, what's the advantage of a revocable trust, if any? The advantage is incapacity planning. So let's say that I've got X amount of dollars in this trust, and my kids decide to have that good old-fashioned dispute, which I hope they never do. And they're fighting over my money, let's say. Well, if they do, the circuit court will say to them, well, Steve has a trust, and he's got X amount of dollars in there. So, you guys can fight all day long over his person, but you cannot fight about this money because this money is in a trust. And 99% of the time, in our experience, the circuit court is going to say, the revocable trust is off limits. That's another thing entirely. It's not part of the guardianship. So I think we could argue that revocable trust is a tool to minimize the possibility of guardianship of the property. Yes, ma'am.
I just wondered if you don't have a irrevocable trust and you have everything set up just in a will, then can the children fight about it
Yes.
afterward?
Yes. Well, and remember, we're talking about during life now. During life. So let's pretend this is a will. And your assets, by very nature, they're still in your own name. So your assets are all here in your own name. If you become incapacitated and your agent is acting for you, how do they manage your assets in the event of your incapacity? They manage it through the power of attorney. So here's that agent, and he or she is managing your assets, paying your bills, taking care of you. And then the other agents, one of the other agents says, I don't like what you're doing. Or I don't like the decisions you're making for her.
But when you say agent, is that someone that you appoint? So if
Yes.
you only appoint one person,
Yes.
then the others can't say anything?
Very good question. Boy, this is a good question. Okay, that's a wonderful question. So let's pretend you had, I'm just going to make up an example. You had 4 kids, and only one of them was your agent, okay? And the other 3 were not. Your question is a very good one, and that's why we have to always, in my opinion, do everything you can to keep these updated. And do everything you can to make sure your estate planning lawyer understands what's going on in your family. So here's why. That child number 1 is the agent. But children 2, 3, and 4 are not agents. But guess what they are? They are interested persons in your estate. So even though they are not your agents, they are interested persons, and they can still launch a guardianship. Yes, sir.
These interested persons, I'm number 1. Should I keep 2, 3, and 4 informed of all my decisions?
If you're number 1,
Yeah.
I think that's a good idea. Now, you have no obligation to do that. You have no obligation to do it. But you know, it's all family situational. We have a wonderful family right now in Silver Spring. The elderly mother died. And there's, I think, 8 kids. And they all get along. I mean, it's amazing. They all get along. And the one child, who is actually the youngest, who's handling everything, she said, should I keep them all informed? And I said, absolutely. Tell every single one of them everything. Don't risk any kind of breakdown at all. But you don't have to.
First question. Suppose you have given this power of attorney to child number 1. And then, since child number 2, 3, 4 are interested person,
Yes.
suppose number 2 dies,
Okay.
then would his descendants, his children, would be beneficiary or not?
Wow. Yes. That's a great question. So child number 2 dies. B, did you
Good scenario.
did you do this?
No. Great scenario.
So let's say child number 2 has 2 kids or 3 kids. Those 3 kids, in my opinion, are interested persons. And they have a right to be heard. Because interested persons are, and I know you'll like this now, because you like this. Interested persons are those persons who would inherit if I died without a will. And because this child had died, those kids would have inherited his share under Maryland law. So they're interested persons.
Under a will. Under a will.
Under intestacy. Okay, and that's another great point that you're bringing up. Interested persons are those persons in the will, if I have one, as well as those who would have inherited if I had no will. So you're absolutely right about that.
But does the revocable living trust then avoid all of that?
All right, the revocable trust. Let's pretend I'm a person that has, unlike a lot of you, I'm a person that has little retirement assets, but I have a lot of non-retirement assets. and I put all my non-retirement assets in my revocable trust. Okay? Those non-retirement assets are going to be shielded from guardianship of the property 99% of the time. But my person is not. Meaning, if they want to fight over the guardianship of my person. Steve's over here living in this community, and he's not well, and he should be moved over here to this facility. They want to fight over that. They can do that, unfortunately. We've seen there are guardianships that are very expensive. So not only is it heartbreaking and expensive, and I don't want to dwell on this terrible subject, but it's something that renders the older person without any control. And there are countless examples of older folks who are not living where they want to live, even though they have assets, because the court has got involved and it becomes very costly. So we want to avoid guardianship.
What this trustee comes in housing?
So where does the trustee come in?
Yeah.
Okay, so you've got a trustee of your revocable trust, and just like agents here, you want to have backup trustees.
Right.
Okay, so a good trust, in my opinion, is going to say, here are my trustees, here are my successor trustees, and if there's anything wrong with those people, here's another person that can appoint a trustee.
Okay.
So there's a concept that I think you'll be interested in called the trust protector. So the trust protector is another role. So let's put the trust protector up here. So what is a trust protector? Well, let's say that you had appointed 2 trustees, and one of them died, the other one was not well and didn't want to serve anymore. Well, most older trusts don't have these flexibility provisions. That just wasn't done years ago. So ideally, you would want a trust that says, my second trustee may appoint a co-trustee or a further trustee if they want to. Now that's not right for everybody, but most people would want to have such a provision. Why? Because if there's no provision and this trustee can't serve anymore, what do you have to do? You have to go to court to get a trustee. And who wants to go to court? So that's one option, is to have flexibility within the trust. Okay? And that's just a matter of restating your old trust so that you can have that flexibility. Another option is a more modern option that is along with this, called the trust protector. So let's pretend that I didn't have this provision and we needed another trustee. Would it be good to have a provision where a trustee could be appointed? You could have a trust protector, which is a person that has very limited power, very limited, and you say to that trust protector, if I become incapacitated or die, you can appoint or remove trustees. So let's say we need a new trustee, trust protector can appoint one. Let's say that you had a revocable trust and you were reading it one day, and God forbid you see an error or an ambiguity in the trust. The trust protector can be given power to go back and change that, fix it. So what we don't want in today's world, generally speaking, is we don't want trust documents that don't have any flexibility. They're too rigid. So that's just something to think about. Let's pretend that we are giving a child, or any beneficiary, a trust. So here's their trust, and they have money in here and it's protected. But we really want to increase the protection of that child. And we say, child, we want you to be your own trustee, but we also want you to be a co-trustee with our bank or our brokerage firm, whatever it may be. BB&T, Sandy Spring Bank, whatever it may be. So there's a co-trustee arrangement. Now what happens when a big bank or something like that gets involved, other than the fees going up? What happens is that there's greater asset protection. Maryland law says that if a child is their own trustee, this was just reconfirmed. If a child is their own trustee, they still have spendthrift creditor protection. What's the spendthrift clause? Your trust would say, any trust that's created for someone else under this trust has asset protection. For the last 150 years, if you say, this trust is spendthrift protected, my beneficiary can't go out here and give away the trust assets or transfer them to a creditor or go down to the Corvette dealer and sign over the trust for a new Corvette. They can't do anything like that. That's spendthrift protection. So you have that even if your child is their own trustee. But, in my opinion, do you have greater creditor protection if there is a independent trustee involved? Let's say that we had M&T Bank as the independent trustee. Is there greater protection? Yes, because the more distant this beneficiary is, the more arm's length they are from their own trust, the greater the creditor protection, in my opinion.
They will charge also. We have to pay the bill, we have to pay him.
Who pays the trustee?
Yeah,
You mean M&T Bank?
right.
That would come out of the trust. So the good news is you have increased creditor protection, okay? They're expensive, you have to shop around for that stuff, okay? But the good news is that they have to provide accountability to the beneficiary, fiduciary responsibility, right? And they have to invest by fiduciary standards, which is a little bit more conservative. You don't want a trustee, let's say your son or your friend, to take the trust money, go down here to their favorite financial advisor and just say, I'm the new trustee, please invest this money for me. You don't want that because those average financial advisors, which may be very good, do they necessarily understand fiduciary investing? Not necessarily. So you as a trustee, or whoever the trustee is, especially if you're a trustee of someone else's money, you want to cover all your bases by having your investment advisor investing by fiduciary standards. So you're covering your fiduciary duty. So Trust Protector is another feature that's a new thing in the law. Where did Trust Protectors come from? They came from places like Alaska, Nevada, South Dakota, Delaware. What do those jurisdictions have in common? Those are asset protection jurisdictions. And there's 14 of them now in the United States. Maryland, unfortunately, is not one of them. But you can take money and put it in an asset protection jurisdiction like one of those, and you can have lifetime asset protection. So those jurisdictions allow certain trusts called asset protection trusts that have a lot of bells and whistle features. And one of those is the Trust Protector. So that's where the Trust Protector concept came from.
So, if we have a revocable trust, then do we still need the power of attorney?
Yes, so I'll go back to this.
And
You still need an advance directive and powers of attorney. Because if you don't have the power of attorney, who's going to manage your non-trust assets? You have to have that. So it's very important to understand that you do need both.
And can they be both same person?
Yes, they can be the same person.
Same person.
Now, young families, they will sometimes ask, gee, I've got kids that are under 18, should I make the trustee and the guardian the same person? So that's something a lot of young families struggle with. Some say yes, some say no.
Could you ever have two powers of attorney?
Yes. You mean,
Because I have two children and it's really hard to choose.
oh, okay.
Like co-power of attorney.
They can be co-agents. So they can be co-agents that they must act jointly, or they can be co-agents where they can act individually.
Because I really have co-trustees on my,
All right.
which I was told not to do, but
You're stuck. Well, a couple of thoughts. If you have a power of attorney that says, I've got two co-agents and they must act jointly, okay, then I would want to have a tiebreaker provision in the revocable trust. I would want to have a provision in there that says, If they disagree, and there's various things you can say, but a good, they have to hire an independent person
Like a mediator?
with their own money.
Their own
With their
money.
what?
Their own money.
With their,
That's the kicker.
At their own expense.
Very smart, very smart.
That's a good one,
guy.
or you could say, you know, I've got a trust and I have a trust protector, my trust protector will be the tiebreaker. Because what you're trying to do there is not create a situation where you have guardianship. It just takes one disagreement to rise to the level of a guardianship.
Okay.
Yeah. Now, in the revocable trust, you can have the same type of thing. They're joint, and they must act jointly. And if there's a disagreement about any fiduciary decision, my trust protector will make the decision, and they must abide by it. So there are ways to handle that. Please, go ahead.
Am I doing a disservice to my beneficiaries to not change everything over to my name, because I have many things that are still my husband's and my name jointly?
Okay. The answer is not really. I mean, you're not doing a disservice to them, actually. It's just an administrative cleanup situation. So there's no question that if you had joint assets with your husband and they're still titled jointly, there's no question they're yours.
Right, and I have his death certificate and the letter of, whatever it's called.
Letter of administration and
Yes,
all
thank
that. Yeah. What I would do though, just remember that middle step? What I would do is I would probably go ahead and, as painful as it is, to engage in that process of just kind of cleaning things up. Here's an example. If you had joint assets with your husband, and just from what you said.
It's land.
Okay, okay. That tells me a little bit that you probably don't have that in your trust.
It is though.
Oh, okay, so there you go. So if it's in your trust, then that means you've already taken care of it.
Okay, because we sort of set up two trusts, his trust, my trust, and it moved to mine when he died.
Okay. So now what you're talking about, and I hope I'm not confusing you, but at someone's death, especially between spouses, there is now a period of administration for the trust. So remember in the will there was administration, and if you don't want probate you have to do with trust, okay? Well, trusts have administration too. You know, that would be a myth that they don't have any. It's just not with court oversight. So, what needed to happen after your husband's death is the trusts that were set up and the property that was in the separate trusts needs to now be administered and moved to where it needs to be.
You mean like retitled?
Retitled. So in a perfect world, you're going to do that. Now there are attorneys and CPAs who may take a lax approach to that and say, well, technically that happened upon death. We don't actually have to retitle things. But we always believe in that best practice of retitling. So if you did that, you may have taken care of a lot of that.
Would that retitling include the children?
The retitling between spouses would mean, okay, I'm a surviving spouse. Now, was there a trust created at my spouse's death? So we'll cover that real quick. I don't know when your trust was done, but let's just say you had a traditional revocable trust. Traditional revocable trust planning would be husband has a revocable trust and wife has a revocable trust. Well, let's say the husband dies first. One of two things is going to happen. The husband is either leaving assets directly to his surviving spouse, and the surviving spouse will then make tax elections and tax planning decisions at that time. Or a traditional approach would be, I, the husband, die first, and I'm creating a further trust for my surviving spouse. And this further trust is typically called, it's got many names, but the modern name is bypass trust. It's also called in older documents, family trust. Some people call it the credit shelter trust. I believe the Collins firm calls it the ABC trust or
I'm
something.
not with it
Yeah, so I'm just throwing that out.
anymore.
Well, okay, okay. So this bypass trust typically, in years past, would hold up to $1 million because that's what the Maryland exemption is right now until the end of the year, and has been for a few years. So, if you had one of these traditional plans, the bypass trust would have been funded at your husband's death. Or, you know, by formula, it would have been funded. And then the question becomes, what is in there? So when you say, am I doing a disservice to my beneficiaries, you're only doing a disservice to them if at your death, this funding was never taken care of after your husband's death. Because that's just something they'll have to sort through. But it's not necessarily a terrible thing, but it's just, it's a best practice to do that. Isn't this exciting?
Okay.
All right. So how,
We're overloaded.
Overload.
oh, okay, all right, are we done, are we at our finishing point?
Yeah, 2
Okay.
o'clock.
Okay, all right. We're not in a hurry, but I don't want to keep you too long either. How many of you want to know about the new portability laws?
The what?
Portability laws, federal portability.
We have no clue.
Okay, so let me throw that out at you and we'll end on that unless you have other questions. But before I go into that portability discussion, are there other things that any of you wanted to know about today that I haven't covered?
What happens in 2015 with the,
With the Maryland?
yeah,
Okay.
yeah, for the, you mentioned the $1 million and what happens?
All right, so here's what's going to happen at the end of this year coming up. Maryland's exemption, which is now 1 million, will become 1.5 million. It's just that simple. A lot of people will not have to pay tax now because of that. But the following year, it's going to go to 2 million, then to 3 million, and then 5.34 million.
Can our new governor revoke that?
Now, he can't, well, he can try to get a change, but I'm not a political, I really don't think that could happen. And the reason I don't think it could happen is because Maryland is one of only 2 states, I understand, that still has a state estate tax. And there was great pressure for Maryland to phase out, to a large degree, this state estate tax. Don't think that's going to happen.
Yeah.
But B's point is very good, and that is, this is part of the portability discussion. Okay, so this is the federal exemption right now, 5,340,000. I'll give you the basics, and then we'll call it a day. 5,340,000 is adjusted for inflation. So your children, unless the law changes, your children in 15 years will see exemptions, I am told, of 8 million apiece. So think about this. Your younger beneficiaries will, and maybe even in your life, you will see where couples can leave $16 million free of federal estate tax and state estate tax. And if certain decisions are made, you can also get a double step up in basis for capital gain. So, no capital gain at death, no federal estate tax up to these huge amounts. Never before seen. Okay. So, the portability discussion is basically this. For Maryland planning, most Maryland residents are still going to have to plan for this. The state estate tax, at least for the next few years. Between spouses, if you properly plan here, you can save tax. You can save Maryland estate tax. But in 2019, Maryland and the federal will rejoin at whatever the federal exemption is at that time. And you know this is going up for inflation, so it'll be a little higher than this, hopefully, by then. Now, what does that mean? That means that in 2019, Maryland is going to adopt portability. What is portability? Well, first of all, portability has nothing to do with planning per se. It has to do with tax. Portability has to do with tax. So here it is. If I'm married and I die, for Maryland purposes, if I don't plan, I will lose my Maryland exemption. So if I don't plan to use this exemption, I lose it. That's what Maryland says. But on the federal level, right now, you don't have to use anything. You can just elect portability. So let's pretend that I'm planning only for federal. If I die, I had $5,340,000 of exemption. My surviving spouse can take everything that I just left her without any of that fancy planning. Because remember, portability has nothing to do with planning. It has to do with tax. And all my surviving spouse has to do is check a box within 9 months, remember that? Within 9 months of my death, all she has to do is check a box. And she can utilize my $5 million, and she has her own $5 million. So for 50 to the last 75 years, you had to plan to utilize this. And you still do for Maryland until 2019 when Maryland adopts portability. But on the federal level, all you have to do is check a box. You don't have to do any of this bypass trust planning. You don't have to do any of that for tax planning. So this is shocking. Okay. Now, that sounds great, right? So here's the second advantage of portability. Portability basically means here's the deceased, and the deceased is leaving everything to their surviving spouse. This is if you're married. Okay? Just like that. And the surviving spouse can check the box, use $10.7 million of exemption between the two of them. Just like that. And at the death of the first spouse, not retirement assets, but non-retirement assets, get a new step up in basis to fair market value for the beneficiaries. So whatever you paid for it, your beneficiaries get it at a new fair market value. That's a good deal, right? In my family, my daughter would sell everything immediately. She gets it, sell it, she would take the money. Now, let's pretend this was my spouse. When my spouse dies, hopefully years later, it gets a second step up in basis. So what, in very, very simple terms, what the government is saying is this. If you leave everything to the survivor, and you don't put any controls on it, your survivor will get a double step up in basis and be able to leave $10.7 million in exemption. Now, the reason that's a big deal is because most people don't want to do that. So let me throw this statistic out. 8 out of 10 men remarry. 4 out of 10 women remarry. So if I'm sitting with a married couple and I ask the spouse, the wife, do you want some control over what happens? What do you think they say?
Yes.
Yes, I want some control. It's not that I don't trust him. It's just the new person is the one I don't trust.
My successor.
The one that brings over the food. Okay. All right, so in all seriousness, that's a control issue. Okay. So people who want control, would they do this? Because the surviving spouse could remarry, give it to a new spouse, disinherit children, all kinds of weird things can happen. Right? So, long story short is this. Most people will, a lot of people I should say, are still going to do the traditional type planning. Remember that bypass trust where the money went in there?
Yeah.
Okay. Here's what was never told to people because it was never an issue. There was no such thing as portability. When that $1 million goes into the bypass trust, It's held there for the surviving spouse. And the deceased spouse has control over that money. At the surviving spouse's death, it goes to where the deceased says it goes. Okay, what's the trade-off? Here it is, make a long story short. The money went into the bypass trust. When it happened, the surviving spouse got a step up in basis to new fair market value. But then the surviving spouse lived for 20 years. And this 1 million grew to 1.7 million, or 2.7 million, whatever it may be. That extra growth does not get a second step up in basis. But that was never discussed because it was never an issue. It was just, that's what you did. So now people say, do I want to leave everything to my spouse in some form that qualifies for the portability type planning? Double step up in basis. No capital gain. Or do I want to do the traditional planning where I will have this issue of capital gain depending on how long the surviving spouse lives? So my point in sharing that with you is you're needing to understand the portability elections is very important, and if not for you, for your kids or other beneficiaries. Because, go ahead, Bea.
Oh, I was just gonna say, how does that affect it, this doesn't apply to me, but somebody where their beneficiaries are out of state? Does that just?
Well, it doesn't affect
whatever
the
state they're living in, or?
Well, this would typically only affect spouses, this portability planning.
But then
Between
when you
spouses.
get down,
But then down the road,
Right.
let's pretend the surviving spouse lives 20 years and there's an extra $2 million of growth. And that $2 million is now subject to capital gain. What the beneficiaries are going to have to do is they're going to get less because of the tax that's going to be paid for capital gain. The deceased controlled it, but ultimately it was taxed more than if the deceased had left everything free of control. Now, there are some ways to control things and still do portability planning. We won't get into all that today. But traditional planning states, I'm controlling it, but it only gets one step up in basis. Portability means 2 steps up in basis. So that's just something for you to know. The only other thing I would tell you about portability is this. And this is funny on one hand, but you'll see why I'm telling you about what your children should know. Your children or yourselves, it is possible to lose some of the portability benefit. So here's an example. Let's say, and this is the last thing we'll go over. Let's say that husband dies first, and he left $1 million to children. Now, why would he do that? Because the children were young, and the surviving spouse didn't need it. And the children can stretch it out much longer. And then he left everything else, and let's just say he had $4 million extra. He left that to the surviving spouse. The $4 million, and it's actually in our example, $4,340,000, is what is called the deceased spouse's unused exemption amount, unused exclusion amount. The government calls this the DSU. The DSU is $4,340,000. Now, let's say that the surviving spouse makes the election, she checks the box, okay? But now they remarry. And when they remarry, they didn't lose this. They still have the $4 million to sue. Because now, remember, they've got their $5 million and they've got this $4.3 million. But now the new spouse dies. I know this is getting a little ridiculous. The new spouse dies. And the new spouse had used all of their exemption. Now the spouse just lost the DSU. Because you only get the DSU of the last surviving spouse. Or the last spouse. Yes, the last spouse. So, although it's possible to have multiple DSUs, depending on...
live in sin, okay.
We got it, don't remarry.
So just know your kids you can lose the DSU. So in that sense, the DSU is like an heroin. So the Sue is important.
Oh, my.
You guys are really good. Thank you. Thanks for coming. Thank you, Sue.
Yeah.
It's good to laugh about these things. Isn't it? Thank you. If you have any questions, please email us or call.
We have a lot of things. Thank you for coming. They have to do with this, you know.
Great. Well, any questions, Steve's current feel free to call me, Bill, talk to Sean, or answer any questions.
Right across from Congressional Plaza, Rockville Hilton sibling, we have an office in that, and what financial decision you have made.
Well, I'm glad that,
We're down coming out for that.
Yeah.